Thank you for joining us. COVID-19 undoubtedly and obviously has presented an unprecedented public health challenge, but we are going to be discussing in this webinar the extent to which it's presented a challenge to the norms of administrative law. What standards give way in an emergency, and to what extent? When do requirements of fairness and due process get diluted to take account of the realities of a crisis, but when are they deemed to be inviolable? And these points have been raised in a number of cases, some already determined, some ongoing. There's been a lot of publicity given to the Good Law Project's challenges to various procurement decisions, which are ongoing and judgment awaited at the moment, and one. But also in the context of challenges to coronavirus regulations, whether they be in the context of education or in the context of the lockdown restrictions. We're going to hear something about all of these, but we're going to kick off today, first of all, to hear from Annalee Howard QC. Annalee took Silk this year. She's something of a polymath, specialising not only in administrative law, but across the range of competition, state aid, procurement, EU law, it goes on. Notably involved from a public law point of view in the Gina Miller case in the Supreme Court, but as her website CV will tell you, currently advising no fewer than 5 government departments on COVID-19 procedures, whether that be departments for education, business, transport, and more. Unfortunately, not all of them have waived privilege to allow her to tell you all about the advice she's been given, but she has agreed to talk to us in particular about the MHRA's ability to roll out the vaccine programme, the challenges which that has presented in terms of adapted regulations for approving and ongoing regulation of those vaccines, to see what lessons can be drawn from a public law perspective. Annalee.
Well, thank you, Robert. That's a very kind introduction. I'm going to try and share my screen, which may inevitably show my technological limitations of getting my PowerPoint slides up, but let's hope this works. And I'll just put it onto the screen if that works. I'm hoping that's worked. What I'm going to try and show in the brief slot I've got today is just how the UK and within the EU framework, as we obviously were in last year, and now under the TCA framework, has used its ingenuity to cope with the pandemic and to make use of emergency exceptions. And I've divided this into 3 main topics. Firstly, what was the EU position when the WHO announced the pandemic in March last year? And obviously those provisions will still apply to Northern Ireland under the Northern Irish Protocol. And then I want to just show a parallel with the TCA provisions, and then give a domestic example as to how the UK government has used its ingenuity on the domestic scheme to respond to this unprecedented crisis. So if I can just go to the next slide, just for the EU, just to give you a snapshot of what happened. The EU Commission learned very quickly the lessons from the 2008 financial crisis and responded very, very quickly to the announcement of the pandemic in March last year. And it issued an communication, which I've put some links in here. If you get the slides, it will give you access to it, but really showing a very rapid response to the economic impacts of the coronavirus, and emphasizing the need for flexibility, not just in competition law, but also procurement and state aid, in order to create a package of measures to allow security of supply, particularly for medicines and PPE, but also to protect the economic fallout and ensuring liquidity for businesses. And the temporary framework was adopted, again, very quickly in March. Initially, that was to apply until December of last year, but it's now been extended to the 31st of December this year, which gives a dedicated hotline for the Commission to approve aid within 24 hours, and it has done that. That framework has been amended repeatedly and expanded to cover different businesses and different measures for the financial system. And obviously, we have both benefited from that regime while we were still within the transition period, but also that framework continues to apply to any aid that must be notified in respect of Northern Ireland. And I think those provisions are useful because we also have parallel provisions now in the UK-EU TCA, where there are specific exceptions for public health or public security, predominantly in the trade in goods sections, but also there are sectoral exceptions within air transport, for example, or energy, electricity. There are specific public health exceptions there. And there is a thematic cooperation provision where the UK is going to cooperate with the EU for health security and will be given ad hoc access to its early warning system for pandemics. And I think the one that's really relevant here is the specific provision in Article 364 of the TCA, which again mirrors the provisions under the TFEU, which allows subsidies on a temporary basis to respond to a global emergency, and that provided they are targeted, proportionate and effective in order to respond to that emergency. Now, obviously, as the UK has come out of the EU, as at the start of this year, our state aid rules are still subject to consultation by BEIS, and we don't really have any UK rules yet. Obviously, that's been listed as a bill in the Queen's speech yesterday, and we will see when those provisions are eventually adopted. But at the moment, we're in a sort of limbo where there's no specific UK rules. So I think the EU rules are a useful parallel, at least at the moment, and obviously govern Northern Ireland. And there are two main provisions. One is the exceptional occurrences, and that's where you have to notify the Commission in the case of Northern Ireland. That will still be ongoing. And I've set some examples of how that particular sectoral compensation has been allowed as an exceptional basis for tourism, for events organisers in Denmark, tax guarantees for airlines, for example. And those subsidies have been authorised very, very quickly under that exceptional occurrence regime. And then there is the temporary framework to which I referred earlier, which again allows direct grants, loans, tax relief up to certain financial limits to particular businesses or particular sectors, provided it's necessary, appropriate and proportionate. And the UK did clear, for example, the suspension of rail franchises and the risk transfer arrangements that were entered into under the new IRMAs. So I think that's a useful parallel for how the UK may apply its own state subsidy control rules, as we must now call them, not state aid, going forwards, particularly in this intervening period. And lastly, I wanted to then just give a domestic example of how the UK government has adapted quickly and promptly to domestic emergency exceptions. And I thought the COVID vaccines was a useful case study. For those of you who are not familiar with the intricacies of the marketing authorization regime, obviously this was an EU framework, which we have then implemented through the human medicines regulations. But the basic proposition is that it is unlawful, it's illegal to sell medicines unless there is a prior marketing authorization that has been granted in the UK by the MHRA. And if there's any marketing or selling of a medicine or a vaccine in this case without the MA, then that is a criminal offence under the regs. Now, there is a temporary exception set out in Reg 174, and that is the entirety of it. So it's simply an exception from that criminal offence and that prohibition where there's a temporary authorisation in response to, and there's a list of circumstances, but one of them is the spread of pathogenic agents. And so if you think in terms of an exception, that's probably the broadest exception that you could ever be granted, entirely discretionary, entirely temporary, without any controls. And in terms of these new vaccines, obviously, there's quite a huge risk element because you're dealing with, particularly with the mRNA vaccines, you're dealing with a brand new technology where you're actually altering the DNA of human cells when it's injected. Or you've got, again, a brand new, even the AstraZeneca vaccine, which is using a live version of the vaccine, still don't know what the side effects may be or what the health and safety may be. Because the important thing about this temporary authorization is that it is not the same as a full marketing authorization. So there will not necessarily be the full scale of protections built into that regime. And although the MHRA conducts the necessary safety and efficacy checks, and there's the detailed scientific opinion that's given before there's any approval, that regime, that exception does not build in for any of the checks or controls that the MA regime has. So in that case, as part of the marketing authorization, there are ancillary obligations on the manufacturer to run pharmacovigilance checks and reports. So if there's any adverse side effects, that all has to be accounted for and has to be reported back so that any measures can be taken. But under the terms of this temporary exception, none of that regime was applicable. So what the MHRA did was to very quickly enact a new part of the regulation, which entitled the MHRA to attach conditions to the authorization, whether that's about its requirements as to the use of the product or its authorization and conditions of storage, for example, conditions of the way in which the vaccine must be stored, particularly important for the Pfizer vaccine, which requires certain temperature controls or a certain time window which it must be administered. Those sorts of detailed controls could then be imposed almost as a contractual mechanism incorporated into the license. And so what has happened is the MHRA has now used those powers to publish and update so-called conditions of authorization, which, as the science evolves, it updates and amends as applicable from time to time. And it's incorporated the various conditions by reference into the scope of its authorization. And what's important is it's made the manufacturers, the pharmaceutical companies, so Pfizer, AstraZeneca, again with any of its supply chain, jointly and separately liable for those conditions. So if they are suddenly put on notice that there's a problem with a vaccine for a particular age group or particular medical conditions, they can adopt the necessary controls that they need, and they will be automatically incorporated into the temporary authorization. But there's also a regime of sticks and carrots so that they have the authorization, but if there's any breach of the conditions, then the approval is taken away. And so that criminal offence will still apply if the vaccines are used, or if they're for a purpose that's not recommended or required, or there is a breach of the condition. So I think this is a very good example of policy making where the MHRA has taken a very broad discretionary power, but attempted to give it some content and to build in controls and limits in order to ensure the safety and efficacy of the medicines. And although this hasn't been litigated, I think for the policymakers, it's a very interesting example of the way in which the government has reacted very quickly to actually make sure that these exceptional powers are not overly broad and can be contained within reasonable limits. So I will stop there and we will move on to our next speaker. Thank you.
Thank you, Anna-Lee. As you come out of your screen sharing, thank you. Our next speaker is Khatija Hafezji. Khatija is a junior of 5 years call and is already making her name as an up-and-coming junior in the public law field. One of the cases in which she's recently appeared as junior counsel is the Article 39 claim against the Secretary of State for Education, which ultimately succeeded in the Court of Appeal. That claim like the case of Shaw, another case in which a claim was brought against the Secretary of State for Education, concerned an allegation that there had been an unlawful failure to consult in introducing new regulations designed to adapt to the circumstances brought about by COVID-19. Here to tell us about those cases, therefore, and what lessons can be drawn for the obligation and extent of the consultation obligation is Khatija.
Thank you, Robert. Can you see that? Yeah, all right. So as Robert kindly said, I'm going to talk about how the courts have treated the question of consultation, particularly with vulnerable groups in the context of the COVID-19 pandemic. This question was recently considered in the two cases listed on the slide there. So the Article 39 challenge was brought on behalf of children in care, and the second was brought on behalf of children with special educational needs by a parent of a child with special educational needs. The context of both of these challenges is that they arose as a result of imminent lockdown in March last year, and the Secretary of State issued two sets of regulations. The first concerned children in care, and the second concerned children with SEN. And in both cases, the regulations modified or effectively watered down the rights and entitlements of these vulnerable children. Now, the reason for this was because it was very difficult at the time for local authorities to comply with their legal obligations. And so the Secretary of State felt that the amendments were necessary in order to ensure that at least some of the obligations could be complied with in the circumstances. So the Article 39 challenge concerned the adoption in children coronavirus amendment regulations, and the full number of changes made by those regulations are extensive. I think in the order of almost 100 changes were made to various Children Act regulations by these amendment regulations. But those of most concern to Article 39 were the three that I've listed there. So the regulations removed statutory timescales for social work visits to children in care, removed timescales for welfare reviews, removed independent oversight and scrutiny in the adoption process, and when you're placing children in out of area placements, so it's very, very far away from their home local authority. The concern from Article 39 is these are all critical to the welfare of vulnerable children, particularly in the context of a pandemic where they're isolated and not in regular contact with their local authority. What DfE did do was carry out a short informal consultation on the changes, mainly with local authorities. Children in care and their representatives and the Children's Commissioner, critically, were not consulted before the changes were made. There was a ministerial submission which indicated that the changes were broadly supported by the sector, and that's something that the Court of Appeal picked up on, and I'll come back to that. The claimant submissions, there are a number of grounds which were argued unsuccessfully below, but the claim focused in the Court of Appeal on the consultation ground. So it was submitted that there was a duty to consult. It arose in three ways, and you'll see there's a statutory duty at the top, and then there were two common law bases for the duty to consult, that being past practice of consultation and conspicuous unfairness. The Secretary of State's response to the claim, they're essentially the foundational premise of the Secretary of State's response was he had a very different view of the regulations. Secretary of State, the regulations were only minor procedural obligations. They were described in the contemporaneous evidence as administrative burdens on local authorities. In other words, these were such insignificant changes that it was not necessary to consult children. Secretary of State also argued that due to the need to implement the regulations as quickly as possible, there wasn't enough time to consult the Children's Commissioner and other representatives. And in the alternative, and this was an argument they developed in oral submissions, it was said that local authorities, as acting in loco parentis for children in care, could in fact represent their wishes and their needs, and so there was no need to consult children separately. At first instance, the Judge Leven-J rejected the submission that these were minor procedural obligations. She rejected the submission that there wasn't enough time to consult the Children's Commissioner. But what she did find is that local authorities and care providers were well placed to represent the views of the affected children, and so there was no need to consult separately with children. Now, the Court of Appeal took a very different view to this. They found that there was a duty to consult with children, and that arose in all of the 3 ways in which the claimant had identified that duty. The court accepted that there was no need for a formal consultation. The informal consultation, primarily by way of emails, that the defendant carried out was sufficient in the circumstances, but found that even if the Secretary of State had not been under a duty to consult, having decided to carry out a consultation, that must be a proper and fair consultation. And in this context, where the Secretary of State carried out a one-sided consultation, only consulting local authorities and not children, this was not a fair consultation. The significant points from my point of view arising out of this case are the court's criticism of the defendant for characterising these as minor changes to children's rights. They consider them to be significant changes to substantive provision of services to vulnerable children. It's a real boost to the role of the Children's Commissioner, who featured prominently in the judgment, but also there was a criticism of the ministerial submission as being potentially misleading because children had not been consulted, and children's rights groups are very much part of the sector. Contrasting that case now to the case of Amber Shaw, which concerns the Special Educational Needs and Disability Coronavirus Amendment Regulations, there were 2 changes here. The first was to the duty to secure special educational provision. That's an absolute duty, and it was turned into a reasonable endeavours duty. And there was a relaxation of the specified timeframes for preparing education and healthcare plans. So now you had to do them as soon as reasonably practicable. There was a rolled up hearing for this due to the urgency. The regulations were due to expire quite soon. The claimant advanced 5 grounds, but at the hearing they were only given permission on grounds 1 and 2. And ground 1, DfE again carried out an informal consultation. So this ground challenged the failure to carry out a formal structured consultation. And you'll note that's very different to how the case was put in Article 39, where there was no challenge to the decision to carry out an informal consultation. And ground 3 concerned the irrationality of laying the regulations before Parliament the day before they came into force. The judgment, the claim was unsuccessful in respect of both of those grounds. The court found in respect of the consultation challenge, there was no duty to consult because there was no past practice of consultation. And there was also a rejection of the argument of conspicuous unfairness not to carry out a formal consultation, because here the court found that there was insufficient time for such a formal consultation, and the informal consultation had in fact taken into account the views of parents of children with SEN and the children themselves and their representative organisations. On ground 3, and this is the argument that it was irrational breach of parliamentary convention to lay the regulations before Parliament only a day before they came into effect. The court found this was non-justiciable pursuant to Article 9 of the Bill of Rights, as it concerned proceedings in Parliament. It's particularly interesting because the Speaker's Council actually supported the claimant's argument that it was only a decision to lay instruments before Parliament that was a proceeding in Parliament. The decision as to when you lay the instrument before Parliament was not a proceeding in Parliament, so said the Speaker's Council. The court rejected that, finding that in the absence of any statutory obligation which affected the laying of secondary legislation, the decision as to when you then lay that instrument before Parliament was in fact a proceeding in Parliament, and so the matter was non-justiciable. But the court went on to say that even if it had found the matter to be justiciable, it would have found in favour of the Secretary of State. The near absence of meaningful parliamentary scrutiny, the court said, was justified given the urgency of the circumstances and the fact that local authorities were finding it impossible to comply with their legal obligations. So just to wrap up, we've looked at 2 cases which arise out of very similar factual backgrounds, but they had very different outcomes. They certainly illuminate which of the requirements of fairness the courts have considered to be mutable and which they've considered to be inviolable in the context of a national emergency. the courts are effectively saying you can dispense with the usual form of a consultation and you can abridge the time frame for a consultation, but what you can't do is dispense with the requirement to carry out a balanced consultation where all the views of the interested parties are represented. And you can see why that is in both of these cases, because in Article 39, the failure to consult with the Children's Commissioner meant that the true impact and the significance of the changes on the children concerned was not properly understood in the court's view. By contrast, in Amber Shaw, the department had in fact consulted with parents, and they had in fact carried out an equality impact assessment, a children's rights impact assessment, and the true impacts of these changes were acknowledged as being detrimental to the education and welfare of children with SEN, but justified in the circumstances. So I hope that was interesting, and I look forward to answering any questions that you might have. And I shall...
Khadija, thank you. Can I take this opportunity to advertise the probably now familiar Q&A function at the bottom of your screens? If you do have questions arising out of any of the talks, please feel free to raise a question in that box and we'll deal with it if we can. There's already been one question to Annalee, which we'll deal with after we've heard from all of our speakers. Just to encourage questions, I'm going to ask one of my own now to Khadija. To what extent can those two judgments be taken by public authorities to represent some kind of encouragement, in practical terms, encouragement not to have a consultation at all?
I mean, I can see how you might take, especially Article 39 that way, where the court says, well, in deciding to carry out a consultation, you need to then do it fairly. You can't have a one-sided consultation. I think it rather depends on the significance of the change that's being made as a result of whatever the public authority is doing. So if it's quite significant, particularly where it concerns vulnerable groups, by not consulting, even if you're not under an express statutory duty to consult, you may be in breach of other public law duties. For example, your Tameside obligations, duty to make reasonable inquiries, failure to take into account relevant considerations. And the failure to consult may be so severe in those circumstances that it might undermine the quality and the rationality of the overall decision that you're making. So it's a dangerous course in those circumstances, I'd say, to not consult at all. And of course, in Article 39, the court did find that there was a duty in any case to consult.
Thank you. Well, any further questions, as I say, are welcomed. We come then to our final speaker in this brief webinar. Our final speaker is Ian Rogers QC, who's been in Silk for 7 years and has managed to rack up no fewer than 14 appearances in the Supreme Court and Privy Council. And from those two facts about Ian, you can take that he is well on his way to becoming a senior statesperson of public law, whatever that means. So we're going to hear from Ian, in particular in the case of Dolan and the lessons that can be drawn from the Court of Appeal's judgment in that case, both on substantive standards of judicial review law and also what lessons can be drawn from it for in practical terms, in terms of practice in the administrative court. Ian.
Thank you, Robert, for that very overgenerous introduction, although it does make me feel very old indeed to think that I might become a senior statesman one day, but some way off, I think. And thank you for the introduction and reference to the Dolan case. In fact, when we were originally discussing what kind of developments in relation to public law there had been as a result of COVID-19, we had in mind that we might cover in some depth some of the procurement judicial reviews, which had involved quite a lot of members of these chambers, but it certainly raised issues, certainly in relation to the facts, as to how the government had had to respond so quickly in the procurement context. And obviously there have been a lot of well-publicized challenges, particularly from the Good Law Project, details of which can be found on their website, where you can find all kinds of interesting documents and indeed pleadings, and you can follow the arguments. But in fact, although we've got one good summary on the Moncton website of the February 21 judgment of Justice Chamberlain, in relation to the Regulation 50 case. I'd refer everyone to that summary on our website. We were hoping that we'd have another judgment by now, but we don't. So actually, I think it's probably best in terms of considering some of the big issues of COVID-19 on public law to focus on the Dolan case. And then I've got one practice point for practitioners to bear in mind. As we move in the admin court increasingly to a situation where, as we leave the pandemic behind, the administrative court judges will want us to resume in-person hearings. And obviously there can be conflicts then in relation to health conditions of legal representatives, people in your team or clients. So I just want to finish with a couple of points on that. So I'll begin just by sharing my screen and hopefully getting that up. Okay, so I think you can see on there the slides, and the Dolan case in particular raised a number of issues as a result of the facts in the context of the pandemic. Dolan case with the coronavirus regulations. So it involves the facts right at the beginning of the pandemic back in March 2020. But of course, what happened was that the government in practice had to amend the coronavirus regulations so quickly to respond as the facts just moved ahead and ahead and ahead in what were, of course, unprecedented times. And that raises a really interesting issue for us as public law practitioners, which falls into the category of the issue of when is a claim academic or when is it hypothetical. Of course, there's been plenty of case law on that. Lots of cases have considered this. But it raises a particular issue in the context of an issue like the pandemic, which was requiring the government to act as fast as it possibly could, similar to the way that the EU responded at an unprecedented rate for the reasons Annalee explained in her talk. But it also raises the question of how the claimants' attitude to the speed at which they proceed also needs to be borne in mind in a situation like the pandemic, where events move so quickly, and you can sometimes find that the challenge you bring and you finesse all of your grounds and you're ready to go, and then you find that the target regulations themselves are about to be changed, or in fact do change, either before your hearing, after your hearing, before judgment. So what happens? How does the issue of whether a claim is academic fall to be judged? So Dolan helps us a little bit with that. How do we deal with that point when there's a very fast moving legislative environment? So I've got the reference there for anyone who needs it for the in the weeklies to the Dolan case. As I said, it concerned a challenge to the lawfulness of the regulations which introduced the lockdown in England. Those were the Health Protection Coronavirus Restrictions England regulations. So they were made in March 2020, but they were subsequently amended on various occasions. And one of the questions was whether those regulations were ultra vires the Parent Act, which was the Public Health Act of 1984 as amended. The problem was that by the time the case came on for a hearing of, I think, permission before Mr. Justice Lewis, the regulations themselves had already been amended quite significantly. Now, after the hearing and before the judgment, the regulations were repealed and replaced. So then the question in the Court of Appeal was, or at least one of the questions was, is the claim challenging the regulations now academic by reference to our standard principles considering that issue? And if the claim is academic, should it be permitted to proceed on public interest grounds in any event? On the first point, the Court of Appeal answered that yes, this was a case in which the grounds, in which the claim was clearly academic. And at paragraph 39 of the Court of Appeal's judgment, it said as much. There had been some interesting submissions from the government's counsel which tried to finesse the reasons why a different approach might be made in relation to different grounds. The Court of Appeal stated the answer quite bluntly: the regulations under challenge have been repealed, and that what really matters, and that makes the challenge academic, but what really matters is whether the court should permit the JR to proceed by reference to the public interest test, and if so, on what grounds. So the answer then was, should it proceed? Yes, was the answer in relation to the ultra-vires issue. In Dolan, there were various challenges also brought on domestic public law grounds and also under various convention rights, bearing in mind that the lockdown obviously potentially raised issues which were run, such as the interference with the right to property, with liberty, and freedom of expression, and so on. So the court dealt with that point as to why only the virus challenge should proceed, notwithstanding the claim was academic, by saying that there is a discretion to hear disputes which become academic. But that discretion, even in the area of public law, must be exercised with caution. Appeals which are academic between the parties should not be heard unless there is a good reason in the public interest for doing so. Now, as to that public interest and applying that public interest test, the Court of Appeal raised the fact and brought it back to our minds the well-known case of Boddington and British Transport Police. So it said that there was a public interest in deciding the issue of the vires of the regulations vis-a-vis the Parent Act, because that issue had the potential to arise for the first time by way of a defence in criminal proceedings. So, for example, those persons who breached the coronavirus regulations would be entitled to raise a public law argument about the vires of those regulations in response to an allegation of a criminal offence by way of a defence to criminal proceedings, see Boddington. And also, so for that reason, that was a reason why the public interest favoured this issue being resolved, even though it had become academic because the regulations had been repealed and replaced. There was a second reason that the court mentioned in this connection, which is that the question of virus continues to be a live issue, even though the particular regulations under challenge have been repealed. New regulations continue to be made under the same enabling power. So therefore, there was a clear public interest in continuing. But in relation to the other grounds, although the court did deal with them with some detail, they were on the basis that they were not they were academic issues. But there is a point about time limits and what happens to time limits in a pandemic, or in fact in a situation like a pandemic, a situation which is so rapidly changing and evolving that you have regulations, legislative amendments to regulations which continually replace one another so quickly that you can hardly get your claim put together and form your grounds of challenge before the legislative target that you're attacking, as it were, is already starting to evolve and change. So how does that affect the claimant's position, given that an application for judicial review, I mean, many people say, well, you have 3 months, but of course you don't have 3 months. You have to file your claim for judicial review promptly, and that's the overriding requirement, as we all know. It's not later than 3 months after the grounds to make the claim first arose. Of course, there's a separate time limit in relation to a claim under the Human Rights Act, which is normally 1 year. But there is a stricter time limit in relation to the procedure in question, in this case, judicial review. So at first instance, Mr. Justice Lewis had not quibbled with the time limit issue at all. But the Court of Appeal, even though there was no substantial argument on this, decided to express its own view on this and said that it had serious doubts about whether the claim was in fact made promptly. And it gave 4 reasons for its position, which everyone should bear in mind in considering a situation like the pandemic. So the first reason was that this situation called for very, very quick action indeed, because the pandemic was such a fast-moving situation from late March. Secondly, the court found that it had serious doubts about whether you could wait your 3 months because there were so many third parties potentially affected, and the fact that some of these involved criminal matters. The third reason was that the issue of virus was actually the subject of public debate. I mean, there were many notable judges who were talking about it, for example, on the television. And so amongst lawyers, this was an issue which was already in the public domain and was being discussed. That was also a reason why the case should have been dealt with very quickly, according to the Court of Appeal. And finally, it was said to the court that one of the reasons to grant permission to bring JR, even if the case had become academic, was because otherwise the claim could never be brought because the regulations have been changed many times. The court put that point back to the claimants in this case and said, well, if anything, that point in itself underlines just how important it is for a challenge such as this one to be brought very soon after the regulations are made. So in the court's view, this was not a case in which the claimants should have taken almost 2 months out of the standard 3 months before the claim form was filed. Notably, there's nothing in the Court of Appeal's judgment as to the impact of the pandemic on the difficulties that legal representatives faced as a result of the pandemic, the switch to home working, childcare issues, and so on. The court has adopted a pretty strict approach in saying that that claimants actually just need to get on with it, and it's a warning that we all need to bear in mind that the overriding requirement is one of promptness. Then in relation to Dolan, there are a couple of points on procedural rigour that we need to remember. The first point about procedural rigour is what's called the rolling approach to judicial review, which the court referred to in a postscript. So a rolling approach to judicial review, or an evolving approach to judicial review, is what the court is concerned about. Increasingly, it says it's finding that there are fresh decisions which have arisen after the original challenge, and sometimes even after the first instance judgment, and that these are then sought to be challenged by way of an amendment to the claim. Now, that had been considered in a previous case, and the court reminded itself that there is no hard and fast rule about so-called rolling or evolving challenges. But it is better generally if JR proceedings are not to be treated as rolling or evolving. And the court said, particularly in a context like the present one under the pandemic, in this situation, regulations were amended and they had to be amended very quickly. And the issues raised in the grounds will often turn on the state of the evidence as it was at a particular time. And so this really ties back into the academic issue. When do claims become academic? When the regulations which you are targeting evolve quite quickly over time, and really is an encouragement for you to get on with it if you are in a situation like the pandemic where you know things are moving so rapidly. As an example, the court said it had been suggested that the statement of facts and grounds would be amended in the present Dolan case to challenge the amended coronavirus regulations of the 3rd of July 2020. The court said that was a very clear example of something that they were right not to pursue. So that would have probably stretched things too far. And then a second point on procedural rigour, which the court wanted to remind all public law practitioners of. It said it was very concerned, and it's not the first time that the court has expressed this view and the judge in question, about its concerns about the length and complexity of the statements of case and skeleton arguments. Now, in this case, obviously, this was a very, very important challenge concerning a matter of the greatest public importance affecting the lives of everyone in the UK. The statement of facts and grounds were 87 pages, and then supplementary grounds were filed, adding a further 13 pages. So we've got 100 pages of the claim. That, the court reminded practitioners, was not compatible with the Administrative Court JR Guide of 2020, although it actually referred to the version which was not in force at the time the claimants filed its claim, but it wasn't too dissimilar, in fact, from the version in force. It was a reminder that the document, the statement of facts and grounds, should be as concise as reasonably possible while setting out the claimant's arguments. The grounds must be stated shortly. Now, the court deprecated the culture that it says has developed in the context of judicial review proceedings for there to be excessive prolixity and complexity in what are supposed to be concise grounds for judicial review. In the court's view, it said that it finds that excessive lengthy pleadings in fact disguise rather than illuminate the good points in the claimant's claims. So that then the court then said that the time had come to refer this matter to the Civil Procedure Rules Committee, which it then did, to reconsider whether there needed to be amendments to the CPR or the practice direction. And that has actually resulted in a change to the paragraph PD 54A, which you can find in the 131st Amendment. Just a final, very, very quick practice point, because I want to make sure that we've got time for any questions. Courts, the admin court is increasingly starting to move towards a resumption of in-person hearings. The Lord Chief Justice's guidance used to be, until quite recently, that the default position was that you should have a remote hearing. But the new guidance no longer states that default position and stresses that over the next few weeks and months, as the number of people who've been vaccinated against COVID increases and restrictions ease, it will be possible and desirable to increase attendance in person. But I emphasize there, it says where it is safe and in the interest of justice. Now, if you are a legal practitioner or you're a member of your team, or indeed a client who needs to attend the hearing has a health reason, what do you do if the court says the night before, well, this has to be held in person, or we wish to hear submissions as to whether we should have an in-person or a remote hearing? Now, in relation to legal practitioners, it's important that you check the Bar Council website. If somebody is clinically vulnerable or extremely clinically vulnerable, and as such in what used to be called the shielding category, then the Bar Council has given guidance which says if it's not possible for you to attend the hearing remotely, and after discussion with the court and your client, the court orders an in-person hearing, you may need to withdraw from the case. Now, of course, that is an extreme position, and I would suggest that there are ways to avoid that. Anyone who wishes to pass on private health information to them should be able to devise a procedure where that information is provided about the legal representative or a member of their team privately to the judge. But of course, you shouldn't abuse that right, and you should make sure that you make your submissions as to whether something should be in person or remote in inter-parties correspondence. But you can explain that information relating to health conditions of a member of your team is provided privately. Now, I would suggest that obviously, as we leave the pandemic behind, the right to a public hearing is going to become more and more important again. But as things stand, of course, the right to life and the risk to health of those who've not been vaccinated or those who are vulnerable is a far more important right in the hierarchy of norms than the right to a public hearing, in my view. So I think it's important that everyone is robust in challenging judges and courteously explaining to them why members of the team may need a remote hearing. Thank you very much. Robert, over to you.
Thanks, Ian. Do you just want briefly to touch on the new page limits which have been introduced by the new practice direction following the court's strong steer?
Oh, yes, Robert. That's a good idea. As I said, that reference from Dolan to ask the Civil Procedure Committee rule to reconsider the CPR or the practice direction has resulted in a recast practice direction 54A. In short, the key takeaways for that are that for statements of facts and grounds, which is normally one document, the total length of that document should be 40 pages. The detailed grounds should also be maximum of 40 pages. And the skeleton arguments for both sides should be 25 pages. In all cases, there is permission, of course, to ask the court to exceed that length. So we have been warned.
Thank you, Ian. If you want to stop sharing your screen, and
yes.
I might add just to that briefly, I think there's also a page limit for summary grounds of defence, which is set at what I regard as a generous 30 pages. I have to say, if I was counsel drafting summary grounds of defence and I stretched to 30 pages, I'd consider that firstly an abject failure, and secondly an implicit admission that there was an arguable point in the claim. But nonetheless, there is that limit of 30 pages should you need it. We've got one question, which was for Anna Lee, and the question from Paul is, am I right in thinking that Pfizer and AstraZeneca's liability is passed on to the government? So Anna Lee, perhaps you can deal with that before we conclude.
Just a short answer is yes. You may remember in the slides I gave you with the new wording for 174, there was some strange wording about recommendations or requirements, and a reference to Regulation 345. Regulation 345 sets out an immunity from civil liability, and what, as part of these reforms in the light of COVID, the MHRA has amended Regulation 345 to introduce a new immunity where there is a temporary authorization. That means that the person that's responsible for putting the vaccine or the medicine on the market, or any manufacturer, or indeed any healthcare professional, are immune from civil liability, and the government effectively bears the risk of any loss or damage as a result of side effects from the vaccines.
Thank you, Anna Lee, and thank you to all the speakers. Those are all the questions which have been raised. Thank you all for attending as well. It's been a very worthwhile webinar, and I hope you found it so. And we'll look forward to seeing you soon. Many thanks and bye-bye.